Smith is now defending his win over Trump on that immunity issue. An appeals court will review the district judge rejecting Trump's claim that a former president should be immune from everything. If you can almost hear the eye rolling in that report, it's because few people, experts in law or politics, have ever agreed with Trump's extreme claim. Indeed, if you're not into the law, but you have a basic memory of American history, something we actually talked about at the top of the program, you may know former presidents are not automatically immune from potential prosecution. That's never been any kind of rule, and that is why, as many know, President Ford pardoned former President Nixon, precisely because otherwise the former president, at that time Nixon, could have been charged.
I, Gerald R. Ford, President of the United States, have granted, and by these presents do grant, a full, free, and absolute pardon unto Richard Nixon for all offenses against the United States which he, Richard Nixon, has committed or may have committed or taken part in during the period from July 20, 1969 through August 9, 1974.
There it was, a pardon for someone who wasn't immune, so he would need a pardon. Now, more recently, top Republicans have operated on the obvious premise that the criminal justice system could potentially put Trump on trial after he left the White House. Take the most powerful Republican in the Senate, Mitch McConnell, emphasizing that exact point during Trump's Senate trial after impeachment.
Trump is still liable for everything he did while he was in office as an ordinary citizen. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
And to be clear, I'm showing you that not just to say, oh, look, that's what they said, but that was so rudimentary, so obvious, so plain that McConnell wasn't making waves by saying it. It was just the state of play. If you want to check the Justice Department, long before Jack Smith or anyone else came along, it has held the view in writing that former presidents can be prosecuted, and that specifically the Constitution permits a former president to be criminally prosecuted for the same offense for which he was impeached and then acquitted by the Senate while in office, as a 2000 memo explains. Now, Trump was acquitted by the Senate for the narrow charge of inciting insurrection. Jack Smith is actually prosecuting him for other charges related to January 6th plots. Now, Trump's appeal claims that he should still have this magic immunity because anything he did was an official act. And he says if he is basically tried, if this case goes forward, then there would be politically motivated prosecutions, which are more menacing and crippling to the presidency than even civil suits. He also accuses Smith of ignoring extensive information about widespread fraud in 2020. Now, that second passage there it's just legally dead on arrival. Judges, and that's who he's talking to, this is not PR, this is not Truth Social, judges know Trump lost the election. They know that no court, let alone the Supreme Court, found the kind of widespread fraud that could alter the outcome in a single state, let alone the several states that Trump lost by. Now, apart from lying about the election he lost, Trump is hoping that his lawyers can get the Supreme Court to embrace either this magic new immunity theory or that this whole process will delay the case. And the guy knows how to delay. Smith is trying to warn this court and eventually the Supreme Court, where you'll see these arguments again if they were to take the case, that even if courts found that tempting, or even if there was a partisan basis, that you were just trying to help Trump, if you think judges operate that way, there would still be larger alarm bells and danger in that precedent. Smith saying that total immunity would shield a president who instructs the FBI director to plant incriminating evidence on a political enemy, or protect a president who incites his supporters during a State of the Union address to kill opposing lawmakers, to ensure that he remains in office unlawfully. Now, Trump's lawyers do not have a very good response about deterring that. They argue instead that the impeachment of a sitting president and then the potential removal by the Senate would be enough. They say, quote, the Senate has the constitutional authority to prosecute a president through impeachment. And there's a little problem here, and I know it might feel like we're getting out into an episode of 24, but I'm literally just reporting exactly what Jack Smith, who's a serious straight shooter, and the Trump lawyers are arguing about. Remember, in Jack Smith's hypothetical, the Senate that the Trump lawyers just mentioned could be intimidated or literally killed on a partisan basis by a murderous authoritarian president to prevent even that thin Senate impeachment and removal accountability. Smith is warning the judges about this amidst a very recent history we lived through, when Trump fans openly tried to hang the sitting vice president at the time, to assassinate Republican Mike Pence. They built a gallows, for goodness sake, and then legislators, including Republicans, you see there, were sent sprinting away to avoid harm or death, a scene that Trump's lawyers want the courts to forget, both in this appeal that I'm telling you about tonight and the potentially more serious criminal trial, if it happens, planned for March. Now, these scenes, which again would become evidence in the March trial, led to the fastest impeachment ever, where Trump's own lawyers actually reiterated this point just mentioned tonight moments ago, that Nixon took the pardon because otherwise he could have been arrested, convicted, and imprisoned. Now, Trump's lawyers even dangled that as the obvious alternative to ousting him from the White House with a few days left over the insurrection impeachment. And I'm going to show you exactly what I mean. Attorney for Trump, Bruce Castor, told the senators how Trump could be arrested just after he's out of office.
After he's out of office, you go and arrest him. So there is no opportunity where the President of the United States can run rampant in January at the end of his term and just go away scot-free. The Department of Justice does know what to do with such people.
Indeed it does. That's Trump's own lawyer saying the thing that Trump's lawyers now claim cannot ever happen. Now, the Justice Department did arrest and book Trump, just as his lawyer admitted they could. The new lawyers are betting on a Hail Mary aimed, we think, based on the available evidence, more at the Supreme Court than the appeals judges hearing this case next week.
He's out of office, you go and arrest him. So there is no opportunity where the President of the United States can run rampant in January at the end of his term and just go away scot-free. The Department of Justice does know what to do with such people.
We're back with Andrew Weissmann. Was Trump's defense lawyer there correct?
As Jack Smith said in his papers to the D.C. Circuit on this issue, he pointed out that exact quote saying that Donald Trump told the Senate that he could be, in fact, prosecuted after he left office. And now that he is out of office, he says, no, I can't be if I have been acquitted. If I've been charged and acquitted by the Senate, then it is a get out of jail free card that he cannot be prosecuted. So he points out that inconsistency. And this really relies on what's called the impeachment judgment clause, which says that
let's get it, Andrew. Let's get into it.
Yep. So the clause says that if you have been impeached and you have been convicted, then you are subject afterwards to being criminally prosecuted, meaning it left it clear that just because you've been removed from office doesn't mean that's the only sanction, that you can actually still face criminal prosecution. Well, Donald Trump says, well, that has a negative implication that if you've been acquitted by the Senate, then you cannot be. And that is really going to be a bit of a battleground in the D.C. Circuit. I think Jack Smith has a much, much better argument here. But that is the sort of debate about why the clause talks about what can happen if you're convicted, but it doesn't talk about what can happen if you are acquitted.
If the D.C. Circuit upholds the lower ruling, which, to generalize, is what usually happens, then the case is back alive. They appeal to the Supreme Court. then what happens, Andrew?
Well, the main issue I see is the Supreme Court could take it, but the question is the speed with which they do that. The normal rules are that the person who loses in the appellate court actually has a lot of time in order to seek further review at the appellate level. In other words, even before you get to the Supreme Court, you can ask the panel that's ruled to reconsider. You can ask the whole court to hear it, because a panel is just 3 judges. You can ask the entire D.C. Circuit judges to hear the case. Why am I raising that? Because all of that entails delay. And then you would say, okay, I have 90 days to appeal and to seek Supreme Court review. And say you have to do this very, very quickly. And I suspect that is what will happen, because that's just way too long a time period to keep this on hold. But that is definitely going to be Donald Trump's play.
Just to clarify, though, and you're saying the D.C. Circuit, or who would create that condition?
The D.C. Circuit could create the restricted timeline to say you only have a certain number of days to seek further review here. And they could say, if you do not seek review in the Supreme Court in a certain number of days, we are sending this back to the district judge to hold the trial. So they could try and shorten up that time period. Obviously, that leaves Donald Trump the ability to go to the Supreme Court and see if they would change that. So each of the courts, the Circuit Court and the Supreme Court, has the ability to lengthen or restrict the time period.
And do you think this Supreme Court would want to jump into this? Because they have the option to stay out of it, as they do most cases.
So that is a really interesting possibility, which is that the D.C. Circuit, I think everyone thinks, including myself, that they're going to affirm Judge Chutkan and say that this case can go forward.